In other words, the future's gonna turn into a Woody Allen movie. What's that tight mask you have on, Council?
Thank you.
I don't know if it was a compliment. That's just-
I'm taking it as one.
Is it comfortable?
No, but the other one broke, so I'm down to my backup mask.
Oh.
I have a bunch of new ones. So I'm gonna get you one of those blue ones.
It's okay.
Yeah.
Yeah, thank you. Very nice.
I have a button for you.
Really?
Slide in the car and backups everywhere.
So, which,
Yours are always very stylish.
if someone comes here to stick up the place.
Just so everybody knows the mics are on.
I think that
Probably they're done.
They'd have to come without a mask.
Mics are on.
Yeah.
Well, we're in the police station, so we'll be fine.
Perfect place to
Yeah.
stage a stick. There's no police here.
Exactly.
We made cop jokes in front of the car. I emailed it to you.
So I wore this jacket. I got this He's always in charge, so. Good specs. So,
Yeah, wow. It's the lowest.
Noted.
Terry Burt, Ron Wellander. Terry's Untitled. We're talking about doing.
So you're the only person we get to see?
Yes.
There, we do not have camera availability other than back here for this room. So the only people that are, the only people on this are the attorneys. We are not having Zoom for the members of the public today. So I wasn't gonna put my camera on at all, but
They can only see Rebecca.
If they get too loud, just turn yours down.
okay.
Good evening, everyone. Welcome and thank you for coming here. I call to order special and joint meeting of Sonoma City Council, Planning Commission, and the Design Review Historic Reservation Commission. October 20, 2021, 6:03. Roll call, please.
We're gonna start with the city council. Mayor Agramati is absent. Vice Mayor Dean,
Here.
Councilmember Barnett,
Here.
Councilmember Felder.
Here.
Thank you. Moving to the planning commission, Commissioner Barbosa, I know is not here tonight. Commissioner Barnett,
Yes?
Commissioner Bohar,
yes.
Commissioner McDonald, Commissioner O'Neill,
Here.
Commissioner Wellander,
Yes.
Commissioner Wyrick.
Here.
Thank you. And then at this time, for the DRHPC, I know we don't have a quorum of that group yet, but we will officially start that meeting when the third member gets here, but they'll be participating as participants at this point. Thank you.
Thank you so much, City Clerk Barr. The purpose for tonight is receive a presentation from our city attorney office on most of the current state housing registration and its potential impact to our Sonoma. So the presentation is via the Zoom, and at the end of the presentation, there will be question and answer period of the time. So that after the Zoom, and then you wish to speak, and please raise your hand and wait to be acknowledge it. If you have not acknowledged it, and then please wait for your turn to speak. In this way, it will then help attorneys to hear your questions and comments. Thank you for your cooperation. Let's go to agenda number 2. Agenda number 2.1, update from the City Attorney's Office on housing legislation. I want to turn over to Jeff Water, our City Attorney.
Thank you. Can you hear me?
Yes.
Excellent. Thank you for joining us tonight. The purpose of the meeting is to discuss the monumental number of pieces of housing legislation that have been enacted over the last 3 years. One of the principal purposes of which has been to significantly reduce the discretionary authority that the council and its subsidiary commissions have in acting upon housing development projects. They are game-changing, these changes. They erode seriously on the ability of the council and commissions to exercise discretion untethered to what are considered objective development standards. Tonight we have two of the attorneys from our firm, the Collintino, Highsmith, and Watley firm, to make a presentation and give guidance on these pieces of legislation. Gary Bell will be speaking tonight. He is a shareholder in the firm, and he currently serves as the city attorney for the city of Auburn and the town attorney for Yountville. He is the general counsel to a variety of special districts in Northern California. His practice covers a range of public law issues. He's particularly specializing in the area of land use and CEQA. Ryan Reed is also joining us tonight and making a presentation on these issues. He's an associate with our firm. He is the city attorney of Weed and acts as the assistant city attorney for Grass Valley, Auburn, and the assistant town attorney for Yountville. He also is an assistant to a variety of general counsel positions for various districts in Northern California. He too provides advice on a variety of municipal law issues, including land use and CEQA. I am going to now turn it over to, I believe, Gary, who will kick the presentation off. Thank you, gentlemen.
All right, thank you for that introduction, Jeff. And I will share my screen now. Can you all hear me correctly here, Rebecca?
Yes.
Okay, great. All right, so as we start this evening, I wanted to give a brief overview of some of the activity in Sacramento and also to define a couple of key terms that are going to be woven throughout the presentation as we talk about the Housing Accountability Act, SB 8, SB 9, SB 35 Streamlining, and the Density Bonus Law. So there were about 60 or so different housing bills during the current legislative session. Sacramento has a 2-year legislative session. They're halfway through it right now. Bills that don't get signed by the governor in the fall in a 2-year session become 2-year bills. So some of those 60 have now been continued over, might be passed next year and signed by the governor. But there's some overarching themes in all of this legislation, the ones that have been signed in the last 3 years and also the ones that are being proposed right now. Those include reduction in local control, which Jeff mentioned briefly, increased use of so-called streamlined ministerial approval, which we'll go into more detail later, increasing the number of units on existing lots, and reduction or elimination of fees, primarily impact fees. So one of the takeaways, though, from this current session and the last one is that the legislature is taking housing seriously. This is a top priority for them, and more bills are coming. So talk about two key terms as we start. There's a distinction between ministerial approval on the one hand. Are you guys hearing me all right?
But the slides aren't matching.
Gary, we're just wondering, are you advancing a slide or you're not there yet?
I'm not quite there yet. This will be the next slide.
Sorry, thank you.
Oh, no problem. So there's a distinction between ministerial approval on one side and discretionary approval on the other. So in the context of CEQA, this matters because CEQA only applies to discretionary approvals, but this also represents a fundamentally different way of reviewing and deciding projects. This distinction applies to all the different things we'll talk about tonight, so that's why it's a background before we start the presentation. So ministerial approval is the opposite of discretionary approval. It involves no discretion. You merely apply a checklist or other clear requirements to the facts or the application in front of you. These are things like yes and no answers and objective standards. If the requirements are met, the public official, that's you all and city staff, has a ministerial duty to approve it. Discretionary approval, on the other hand, requires judgment and deliberation. You're essentially asking, is this a good idea? These type of approvals require the application of your subjective standards based on personal experience. All right, so with that in mind, here are the things we're going to cover tonight. First, we're going to talk about the Housing Accountability Act and the Housing Crisis Act of 2019. We'll then touch on Senate Bill 8 and Senate Bill 9, which is part of the big housing package that was just signed by the governor a few weeks back. We'll talk about SB 35 Streamlining, which is a special ministerial approval process for a subset of affordable projects. And then we'll talk about the density bonus law, which necessarily comes into play when you're dealing with a percentage of affordable units. And of course, we'll leave time for questions and answers at the end. So the Housing Accountability Act was first adopted in 1982. It's been around for a while, but the legislature is using this as its vehicle for lots of housing reforms. They picked this up about 4 years ago. It's been amended 7 times since. That's more than 1 time a year. This is where they're focusing a lot of their effort on the changes to local control and to promote housing in the state. Housing Crisis Act of 2019 amended the Housing Accountability Act and other provisions. According to the Department of Housing and Community Development, this is the crux of the Housing Accountability Act in a nutshell. It establishes the state's overarching policy that a local government may not deny, reduce the density of, or make infeasible housing development projects, emergency shelters, or farm worker housing that are consistent with objective local development standards. There's a lot going on there, and we'll unpack it, but that's the takeaway main thrust of the Housing Accountability Act. I've included this flowchart here in the material you have with you in the presentation because it is useful. In the future, when you encounter a Housing Accountability Act project, this is a good place to start. This is provided by the Housing and Community Development Department, and it's a way to think through what sort of standards you're applying, what findings you would need to make, whether or not the project is subject to the Housing Accountability Act, and the types of questions that you should be asking. On the left there is affordable projects, which we'll talk about in a second, and on the right is all other projects, including non-affordable projects that are subject to the Housing Accountability Act. So as a threshold issue, the Housing Accountability Act applies to a housing development project, quote unquote. That's defined in the Housing Accountability Act as a use consisting of residential units only, mixed-use developments consisting of residential and non-residential uses with at least 2/3 of the square footage designated for residential use, or transitional or supportive housing. It's important that they use the plural units there. It's not 1 unit, it's 2 or more units, meaning that a single-family home proposed as a single unit is outside the scope of this. But if 2 or more units is being proposed in the same application, the Housing Accountability Act is triggered. Those 2 or more units can be attached and detached and can be on 1 or more parcels. The key is that they are all included in a single application submitted to the city. It also applies to transitional housing and supportive housing. Those definitions are there. These applications are less common in some jurisdictions, but if you get one, Housing Accountability Act applies as well. For affordable housing subject to the Housing Accountability Act, we talk about very low, and moderate income households. What the Housing Accountability Act means is that at least 20% of the total units will be sold or rented to lower income households, where the monthly cost does not exceed 30% of 60% of the area median income. Now, I know that the city has an inclusionary housing ordinance that requires 25%, so this will be triggered for projects that are subject to that ordinance as well. Or 100% of the units will be sold or rented to persons and families of moderate income or persons and families of middle income, with a monthly cost not to exceed 30% of 100% of AMI. These amounts are determined by HCD. There's a process in the Health and Safety Code for them to crunch the numbers based on data for your community, and they publish what these percentages are in the area median income. That data is available on the website as well. So for projects that do have those affordable percentages, not all of them, but the ones that have those affordable percentages, the Housing Accountability Act says the city cannot disapprove that project unless one of the following findings are made. You have a compliant housing element and you've met your RENA allocation for all income categories proposed for the project. Now, I spoke to your planning director today and you got to know that that is true, meaning the city can make that finding for purposes of affordable projects under the Housing Accountability Act. There are also 4 other findings there that could be made. Project has a specific adverse impact on public health or safety. Denial is required to comply with law. It's on land that's zoned for agricultural use, or there's inadequate water or sewer, or the project is inconsistent with both zoning and general plan land use designations not listed in the housing element, and there are adequate alternative sites to accommodate the RENA allocation. So if one of these findings couldn't be made, Housing Accountability Act says it would be a violation not to approve that affordable project. In your case, the first finding can be made, perhaps others too. This standard of review here applies once you make those findings for an affordable project and to any other project subject to the Housing Accountability Act. 2 units, 3 units, 4 units, 5 units, including those projects that have a percentage of affordable that is subject to the Housing Accountability Act. So if the project is consistent with your objective general plan, zoning, subdivision, and design standards, the city cannot disapprove the project or impose conditions that reduce its density unless both of the following findings are made. There's a specific adverse impact on public health or safety, and there's no feasible method to satisfactorily mitigate or avoid the adverse impact. There's a couple different things going on there. You've got objective standards, has to be consistent with those. That's the first step. If it is consistent, can't disapprove the project unless these findings are made. Now, for what it's worth, HCD does not think these findings will be made very often, if at all. They think they take the position that the bar is pretty high, and based on the wording, it likely is. If there's no feasible method, meaning there's just no alternative, there's no way to mitigate it, that's a pretty high standard. So the Housing Accountability Act contains the following definition of objective. It involves no personal or subjective judgment by a public official and being uniformly verifiable by reference to an external and uniform benchmark or criterion available and knowable by both the development applicant or proponent and the public official. I think it's worth noting that the legislature thought it necessary to include uniformly and uniform in the same definition, but they're trying to drive home a point here, which is no personal or subjective judgment. It's got to be something that's obvious on its face, not open to dispute or debate, and not something that reasonable people can disagree about. If 2 different people in the room could think a standard means something different or slightly different, it's likely not objective. It's a high bar, that's how the law defines it. So there are timelines in the Housing Accountability Act. An application is deemed complete if a preliminary application under the Permit Streamlining Act is submitted. Now this process, Permit Streamlining Act was amended to include this preliminary application process. The statute contains a list of things that the application has to contain. If it has all of that, it freezes your standards and fees in place while the proponent assembles the remaining information in 180 days. If they don't choose to use that process, and they don't have to, the application is determined to be complete when it's found complete under the Permit Streamlining Act. And that's the back and forth the planning staff goes with applicants to make sure the application has everything, 30 days back and forth. Eventually, it's deemed complete. So here are the timelines for the city to respond, and they're pretty quick. If the city determines the project is inconsistent or not in compliance or conformity with a plan, program, policy, ordinance, or other standard, the city has to provide written documentation to the applicant within 30 days of the project being determined to be complete if you have 150 or fewer units, or within 60 days if there are more than 150 units, otherwise deemed consistent. To break that down, if the city doesn't respond at all, this timeline will be triggered, the project will be deemed consistent with those standards, and if things are not included within that letter, the same possibility exists. This is something that, practically speaking, is done at the staff level. They're reviewing the application, they're determining if it's complete, whether or not it contains all of the information. There's a back and forth with the applicant. These letters are sent at staff level to make this determination, and it really guides the project for the remaining time as it goes through before it reaches the design review stage, the planning commission, or on appeal or directly to the city council. But this part of the process is crucial because here is where the determination on objective standards is made, and also which objective standards are going to be argued over later. It's not included in here, it's deemed consistent. CEQA still applies to Housing Accountability Act projects. That's not true for all the ones we'll talk about tonight, but it does apply to these projects. The project is denied, of course, if you vote to deny it, or if you fail to meet the deadlines on projects after CEQA approval under the Permit Streamlining Act, which is typically 180 days after CEQA approval. So we'll consider for a moment objective standards that are typical and that the city has within its design code as well. Things like the use will not be detrimental to health, use will not be detrimental or injurious to property, use is compatible with existing and future land uses. There's a couple more that a lot of different cities have. Project would maintain and enhance community character and would not be detrimental to public health, safety, or welfare. But these are common. All 483 cities in the state of California have something like this for approval of projects. They are standards, they're findings that you make in order to approve these projects, either design review or for a use permit or for some other aspect of the project. And this is about determining whether or not this project fits in the community and is a good fit. If you think back to the definition of objective and also discretionary approval, this is about subjective analysis. If you're answering the question, will this project be detrimental to health? It necessarily requires decision makers to answer that question based on their opinion and their subjective experience. And these are the type of standards that the new law is seeking to avoid. So there's a way to reconfigure these though. There's an opportunity to rethink performance and content-based criteria and standards. So things like should, compatible, within, and be specific. Truth is, for these types of standards here, detrimental to health, injurious to property, every community means something when they think about this, and they might mean something specific. And to the extent you can, and there's an agreement, these types of things can be turned into objective standards and boiled down into something more specific that can be applied under the Housing Accountability Act, as long as there's the effort to distill them into something that is objective. But there's an opportunity to rethink these and put them into objective standards, and many jurisdictions are doing that. Some are even adopting standards only for HA, Housing Accountability Act projects. The upshot to that is you can have them all in one place. As it stands right now, you get an application, you've got to go through every standard in the code and figure out what's objective, what's not, which ones apply to the project. If you take the time to put them all in one place, it can save time for staff, it can be easier for applicants, and it can be easier for decision makers too when the application comes in front of you. I'll hand it over to Ryan for a couple slides.
Thanks, Gary. Can everybody hear me?
Yes.
Okay, great. So just to talk briefly about the Housing Crisis Act of 2019, which was a part of a larger bill called Senate Bill 330, which amended in a lot of the ways that Gary just talked about, the Housing Accountability Act, and then added some other substantive provisions that are going to affect mostly procedurally how public agencies address projects, but with some substantive requirements as well. So the first portion of this is of the Housing Crisis Act was to prohibit agencies from holding more than 5 hearings on a housing development project that complies with applicable objective general plan and zoning standards in effect when the application was deemed complete under the Permit Streamlining Act. So once it's been deemed complete, no more than 5 hearings. A hearing is pretty broadly defined. It can include workshops or similar pretty informal public hearings conducted by the city with respect to that housing development project. And it's whether it doesn't matter whether the hearing is ultimately heard by a legislative body of the city, planning agency of the city, or another agency, commission, hearing officer, or body of the city. So it's a pretty broad definition. In addition, the Housing Crisis Act limited agencies from adopting development policies, standards, and conditions, which would in effect or actually impose moratorium on housing development, unless those housing moratoria are approved by the Department of Housing and Community Development. The key point of the Housing Crisis Act was that on or after January 1st, 2020, agencies were prohibited or are prohibited from imposing or enforcing design standards that are established after that January 1, 2020 date that are not objective design standards. There's a pretty uniform definition of what objective standards are. Here it is defined by the code as any design standard that involves no personal or subjective judgment by a public official and that is uniformly verifiable by reference to an external and uniform benchmark or criterion available and is knowable by both the development applicant or proponent and the public before submittal of an application. This basically means, again, that when you're looking at a project standard or a standard potentially applicable to the project, that it is knowable and obvious to all of the parties involved. And finally, the Housing Crisis Act of 2019 established a few principles regarding no net loss for housing units and for density and intensity requirements. There's really 2 parts of this. The first is that public agencies are not allowed to reduce the allowable building density of residential parcels, so downzoning, for example, below that which was in effect as of January 1, 2018, unless the city identifies other sites where it can proportionally increase that intensity. So basically, if you're going to downzone one lot that allows residential zoning, then you have to find that density somewhere else. The second part of this is that public agencies can't allow demolition of residential dwelling units unless the projects generally create at least as many residential dwelling units as were demolished as part of that project. Next slide. So the Housing Crisis Act of 2019 was intended to sunset in 2025, on I believe January 1, 2025. Then came along Senate Bill number 8, which you've probably heard a lot of about, packaged with Senate Bill number 9. SB 8 is actually relatively simple in that it makes a number of changes to the standards that were set in the Housing Crisis Act. First, it extends the Housing Crisis Act to until 2030, so it no longer sunsets in 2025. We have almost 9, or I guess 8 and a little bit more years left of it. After January 1, 2022, so coming up in a few months, the term housing development project under the Housing Crisis Act is modified to include discretionary and ministerial projects, which includes projects now to construct single dwelling units. So before, the Housing Crisis Act shared a definition with the Housing Accountability Act, which was 2 or more units. And now it has been specifically narrowed to apply as well to single-family projects. So single-family projects, for example, will be subject to that 5 hearing standard. In addition, the Senate Bill number 8 extends the prohibition on application of new ordinances, policies, or standards to a proposed affordable dwelling project from 2.5 years from the date of the preliminary application to 3.5 years. So basically this is saying that if somebody has submitted a preliminary application, they've frozen the standard or the ordinances, policies, and standards that are in effect at that time. They then now used to have 2.5 years to commence the project for that standard to still apply, or to freeze the standards in place at that time. Now they have 3.5 years from date of the preliminary application to commence their project. If it's not commenced at that point, then new requirements apply. Thanks. Next, Gary. There are a number of other substantive provisions, some that developers are looking at regarding requirements to provide relocation benefits and a right of first refusal to occupants of lower income households, modifying some existing standards. Then there's just a few provisions that clarify what the existing law meant. First, they clarify that receipt of a density bonus does not mean a project is inconsistent with the general plan or zoning. That's something that most cities had intuited at that already. But a project is consistent with the general plan and zoning, even if it requires receipt of a density, or it includes receipt of a density bonus. Otherwise, that would kind of be an end around on general plan consistency. The SB 8 clarifies that appeals in public meetings related to density bonuses are counted towards 5 hearings, the 5 hearing requirement. Basically anything that you are, any type of public hearing related to the project will count towards the 5 hearings, and that includes appeals. So if there's a development review committee hearing, maybe another hearing or 2 that's been continued, goes to the planning commission for approval. There's an appeal from the planning commission to the city council on whatever this project is. That appeal also counts towards the 5 hearing limit. And finally, the SB 8 clarifies provisions of the no net loss requirements. Specifically, as I said, the city can't either reduce the allowable building density of residential parcels or allow existing residential dwelling units to be demolished unless that density is made up either on the site by replacement of the residential dwelling units demolished, or by finding other areas of the city to increase allowable density. This SB 8 clarifies that generally that makeup, that finding density elsewhere, or the project replacing the residential dwelling units has to occur immediately. It has to occur at the same meeting where or hearing where the project is approved that would reduce density or would demolish units. But in certain circumstances, in particular, the request of an applicant, that immediately standard is 180 days. So the city has 180 days to either upzone somewhere else, or for an applicant to identify the additional dwelling units that are replacing those that have been demolished. Next slide. And just back to you, Gary.
Yeah, thanks. So far we've talked about objective standards under the Housing Accountability Act. If those are met, you have to make health and safety findings in order to deny the project. And we know that has to be done in 5 hearings, which is a pretty quick turnaround, especially if you consider the possibility of appeals and also design review and the substantive stuff not necessarily going at the same time. It's a pretty quick turnaround, and objective standards could be limited. So we'll talk about Housing Accountability Act enforcement now, and then we'll talk about a few cases. So an applicant, anyone who's eligible to apply for residency in the project or housing organization, can enforce the Housing Accountability Act. That's specifically provided for in the law. A writ of mandate applies to overturn the city's decision. Typically when you do administrative decisions at the city council level, or your planning commission or your design review commission, those would be subject to a writ. And the court, trial court essentially asks whether or not the city proceeded in a manner required by law, whether or not the decision was supported by findings, and whether or not the findings were supported by evidence. Those are the three questions that are asked in this type of lawsuit. So there's standards of review. You noticed earlier that the Housing Accountability Act requires that you all make certain findings based on a preponderance of the evidence, which basically means more likely than not. But when a court looks at your decision, they're going to decide whether or not there's substantial evidence to support your finding of preponderance of the evidence. So the takeaway from this is to ensure that there's an adequate administrative record to support each of your findings and explain why they're made based on the evidence that's in the record. That evidence can be writings, testimonies, staff report, any other documents that are provided, just like your other administrative record. But to include those findings and to make it clear why you're making them based on that evidence, so there's a clear record before and if it goes to court. So we'll talk about 4 different cases that have touched on this. Each of them highlights a different thing that we've just discussed. It can be more interesting to talk about the facts of a case, because these are real life. In some cases, 2 months ago, the California Renters Legal Advocacy case came out. City of Los Angeles was last year. Berkeley case a few years back. And then the Honcharu case, the first one we'll talk about, was one of the more recent case law to develop under the Housing Accountability Act. So in this case, there's a long history of litigation. This gentleman has sued Stanislaus County, I think, 3 or 4 times since 2008, 2009. They are still in litigation to this day. This is one of many published Court of Appeal cases to come out of this litigation. And he's not letting this go, and neither is the county. So he had proposed to subdivide 33.7 acre parcel into 8 different parcels, ranging in size from 0.5 to 5 acres, including one 12-acre remainder that would remain undeveloped. Some of this land was zoned agricultural, and some was zoned historical site district. The historical district properties were served by a community services district that provided water. The county did not provide water out there. It was rural, so the local special district did. When he asked whether or not they were going to provide water out to the subdivision he was proposing, they said no. They gave a will not serve letter. They don't have the infrastructure. They don't have the water to do it. There's concerns over traffic, water availability, contamination from the septic systems that were out there already, and maintaining the historical character of the area. So this went before the Planning Commission. Important to remember that at this point, it's just a subdivision map. Not proposing to build anything yet. He's just subdividing property under the Subdivision Map Act. Of course, on each of those parcels, it is envisioned that there'll be a single-family home in the future. So this proposal includes 8 units, even though he's subdividing the property only at this stage of the process. So Planning Commission denies this on a 6-2 vote. Primary concern is this will not serve letter. How are we going to put in a subdivision, put in houses if they're not going to have water? It's a legitimate concern. They appealed to the Board of Supervisors, which unanimously disapproved of the project. Project site is not physically suitable for this proposed development. That's what they concluded. They relied heavily on the will not serve letter. There's a couple takeaways from this case. First is, Housing Accountability Act is not limited to affordable housing. That's one of the things the county argued. Housing Accountability Act is about affordable housing. This isn't affordable housing, therefore it doesn't apply. That argument was dismissed. It applies to all. Housing units are proposed because of single-family dwellings on each of these 8 lots. What's the takeaway? If the housing development project complies with objective standards, county can only deny it based on the findings. Project would have specific adverse impact on public health or safety, no feasible method to satisfactorily mitigate it. The Planning Commission and the Board of Supervisors did not make these findings in this case, therefore it violated the Housing Accountability Act, and it was sent back down for further proceedings. San Francisco Bay Area Renters Federation versus the City of Berkeley, a recent case from 2017. This was a proposal to demolish a single residential unit and construct 3 residential units in its place. There's some pictures that follow this case, but it's a very narrow street, got some tight houses with very little setback. and not a lot of parking anywhere, not a lot of off-street parking at all, and none on the street either. So the community was already pretty tightly packed into this street. And a developer came in, wanted to demolish one of the single units, construct 3 on this very small parcel. The other folks that lived on the street were not pleased with this proposal. The zoning adjustment board approved it, finding that the project complied with all objective general plan and zoning standards, including design review, in effect at the time the application was deemed complete, and a use permit was issued. Public opposition at this point really mounted, including an outreach campaign with the city council and attending city council meetings. This project was appealed to the city council, which overturned the zoning adjustment board's decision, citing the same concerns that the public had: parking, privacy, light, view access, and crowding in a very tight neighborhood. Same standards apply here. So when the project complies with objective standards, you've got to make these 2 findings. City council did not make them when overturning the zoning board. The trial court decision and settlement for the city council to rehear the appeal. So trial court issues an adverse decision. They managed to come to a settlement where the city council is going to rehear it and make their decision again. City council took a slightly different tack on this when it came back before them, even under the settlement. They vacated their resolution, but they denied the demolition permit that was accompanying the project. The project wasn't just a use permit to build what they were going to build, it was also a demo permit. And the city council took the position that the demo permit's not subject to the Housing Accountability Act because that permit itself doesn't involve any units, and therefore they could deny it and not make the findings that the Housing Accountability Act requires. Perhaps not surprisingly, parties went back to court. The court orders a housing accountability analysis per the settlement. They ultimately did settle, and the project was allowed to be constructed. I think the takeaway from this is to not dissect the project and to try to piecemeal it in a way that to avoid the Housing Accountability Act, particularly when in litigation. And I'll note that the AHCD does take the position that all aspects of the project, all entitlements are subject to it when one part is. That's part of the regulations or guidance that they've adopted. All right, so this case was from last year, District Square LLC versus the City of Los Angeles. This is one of the first cases after the post-2017 amendments to the Housing Accountability Act. So the Director of Planning in the City of LA approved a permit for a 577 unit project. This is the sort of thing done at the staff level in the City of LA for a mixed use building, finding it met all objective standards and was exempt from CEQA. The project was within the allowable density for the zone that it was in, but the project was appealed to the Planning Commission, which denied the project because of impact on gentrification and displacement of existing residents. They issued a letter of determination 6 months after the Planning Commission denied the project. Now you think based on the past cases that we just looked at, that this would be remanded back to the Planning Commission to reconsider its decision and to make these findings under the Housing Accountability Act and to have another go at it. And typically when courts review administrative decisions of cities, that is what they do. They don't want to overstep their role. They don't want to step into the shoes of the city and the city decision makers. So they will send it back and say, here's what the law requires. Please take another opportunity to review this and make the proper findings. But that didn't happen in this case, and it's unusual. A couple reasons. Court first found that the project was deemed consistent with all of the city policies because that notice that the city was supposed to give within 60 days never happened. And under the Housing Accountability Act, project is therefore deemed consistent with all standards. So now, the project's consistent with all the objective standards, regardless of what it actually is. And therefore, the city was required to approve it, unless those findings could be made. But the court ordered the city simply to approve the project, not to reconsider its findings, not to reconsider the application. The court found that the Planning Commission went on its own frolic and detour, acting knowingly and deliberately to violate the law. Part of that is there was advice and testimony at the Planning Commission hearing where these issues were actually brought up. Housing accountability was brought up, these issues were brought up, and Planning Commission took a contrary position. This is the most recent case. Early September, a little over a month ago, this came out. And it gives us some insight into what qualifies as an objective standard under the Housing Accountability Act and that definition that we talked about a little bit earlier. So this was a proposal to build a 4-story, 10-unit apartment building. Staff reviewed it, determined compliance with the general plan and design standards, recommended that the Planning Commission approve it as well in a staff report and a hearing for the Planning Commission. There was public opposition to this project based on its location and size and whether or not it met the design standards. Planning Commission, despite staff's recommendation, directed staff to prepare a resolution denying the project. It brought that back later. The issue, though, is compliance with this particular design standard. And the city had a design standard that read as follows. If more than 1-story variation in height between adjacent buildings, a transition or step in height is necessary to, quote, ease the transition. So the first part of that, if more than 1-story variation in height between adjacent buildings, you can identify adjacent buildings pretty quickly. Is there more than 1-story variation in height? It appears to be objective. It's the second part of it that raises concerns. A transition or step in height is necessary to ease transition. So the Planning Commission denied this project, appealed to the City Council, and the City Council upheld that denial. And off to court they went. The trial court initially found that that design standard was objective. On appeal, the court reviewed the history of general plans and also the Housing Accountability Act, and including the Housing Accountability Act provision that it must be construed to provide additional housing. Court found that the design standard wasn't objective. It requires a transition or step and provides no guidance on what meets the standard. And city staff, the city took different positions at the Planning Commission, City Council, and in court. And I think what the court was saying there is, if the decision makers and staff think about this differently, then it doesn't meet the definition of objective in the Housing Accountability Act. I'll hand it back over to Ryan.
Great, thanks, Gary. So the big new bill in town, as I'm sure you've all heard a lot of rumblings about, is Senate Bill number 9, SB 9. So there's a few key takeaways to talk about here for SB 9 and specifically what it does before we can talk a little bit more about the specifics of the parameters set up by SB 9. So the first takeaway is that lot splits are now allowed by right in single-family residential zones. That means, again, that you can the city must ministerially approve splitting one lot into two within single-family residential zones. The second is that ministerial approval is required for up to 2 units, so typically a duplex, and those 2 units exclude allowances under the accessory dwelling unit law in single-family residential zones. And ultimately, the broadest parameter here is that a maximum of 4 dwelling units are allowed on the original single-family lot, or if it's split, then 2 on each parcel. Next slide. So, as I said, the standards for the ministerial approval of 2 units are actually pretty simple. 2 units are going to be allowed typically in a duplex in any single-family residential zone, unless one of these 2 standards is true, with some other limited exceptions that I'll talk about in a few moments. So the first standard is the city does not have to approve ministerial use under SB 9 if it can make written findings that the project would have specific, unmitigatable adverse impacts on public health and safety or the physical environment. Gary talked earlier about HCD's general interpretation of the types of specific adverse impacts on public health or safety. HCD has taken the position, at least in the HAA, the Housing Accountability Act context, that it's a pretty high bar. So we're really looking at pretty obvious safety issues related to the property that preclude it, for some reason, from being approved for 2 units. The second general standard is that the development, the city doesn't have to ministerially approve 2 units. If development would require demolition of more than 25% of the exterior walls of the structure, of the existing structure, unless that unit has either not been occupied by tenants within the last 3 years, or alternatively, cities are actually given the option of waiving this provision. So if the cities can adopt an ordinance that implements Senate Bill 9, and that can waive this 25% of exterior wall requirement. But generally, this provision is aimed at situations where folks might be knocking down more than 25%, so that would be really more than one wall of a structure, and then moving, that was previously serving residential tenants. So it's a tenant protection measure, really. And under SB 9, cities are still allowed to impose objective standards, with a few exceptions that I'll talk about in a moment, but also with the exceptions that any objective standards that are on the books, with objective being defined as it's defined elsewhere in state law, as we've talked about several times, that no personal or subjective judgment for the city standard. Basically, the city can impose objective standards unless, and to the extent those standards on the books would preclude construction of up to 2 units, or that would physically preclude either of the 2 units from being at least 800 square feet in floor area. So for the section of SB 9 that applies for 2 or more units or 2 units on a property, the duplex rule you might call it, objective standards can apply, but they can't preclude construction of those 2 units, and they can't preclude those 2 units from being at least 800 square feet. Next slide. So folks have generally divided SB 9 into 4 key areas. That would be regulations addressing standards for housing allowed and lot splits allowed under SB 9, regulations addressing the location that SB 9 applies in, regulations addressing potential displacement of existing residents, of existing tenants, and some regulations that address potential overdevelopment. Next slide. So for lot splits, new parcels must be at least 1,200 square feet and may not be smaller than 40% of the original parcel. Practically, depending on the size of lots within your city, it is unlikely that there will be many or any parcels that are 1,200 square feet because of that 40% threshold. What that's saying is basically the lots have to be, if a lot is split under SB 9, it has to be split relatively evenly with about 10% wiggle room. So for example, my house is on a lot of about 5,500 square feet. So I could split that into 2 lots under SB 9, but I would be limited to doing it about, let's see, my math is terrible, maybe 2,500 to 2,900 square feet, 2,500 for one lot, 29 for the other. You can't have one lot that's much smaller than the other. The city can require 1 off-street parking unit space per unit with some limited exceptions. As I said before, the city can't impose standards, those objective standards that would preclude construction of up to 2 units that are at least 800 square feet in floor area. So basically, these objective standards apply except to the extent that you're prohibiting the 1,200 square foot parcel, you're prohibiting 2 units on those parcels of 800 square feet each. And finally, as with accessory dwelling units, these developments under SB 9 are subject to 4-foot side and rear setbacks for most structures, and then for existing structures, there's no setback requirement if it is put in the same location as an existing structure. So if, for example, you split an existing structure into a duplex and didn't expand, or if it's rebuilt in the same configuration and location as an existing structure was. Next slide. So for the location of that SB 9 applies to, Under SB 9, the parcel, lot, or development, so the lot that is being split into two or the development of 2 units on that lot must be located in a single-family residential zone. I think this is something that we've already seen a lot of questions about, and we can talk about it a little bit more maybe in the questions if people are interested, but this SB 9 does not define what a single-family residential zone is. So agencies have started to take 2 interpretations, one being that a single-family residential zone is a zone where only single-family residential is allowed, which is typically referred to as the R1 zone in most cities, but that SB 9 does not apply in other zones that allow single-family residential, but other multifamily residential as well. There is justification for that approach, but and I'll be brief here and we can talk about this later as if there is interest. The alternative approach is that single-family residential zone applies, it includes any residential zone where single family is allowed. The reason that people take that approach is, first, single-family residential zone is a relatively ambiguous provision in state law, and courts, as Gary just talked about, have pretty much uniformly interpreted this slate of housing laws in the way that most benefits the folks that are trying to build housing. So the more permissive standard here is that single-family residential zone means any zone that allows single-family residential buildings. That would preclude some cities that have zones that only allow multifamily or mixed use, for example. Second, and this applies to a good amount of the city of Sonoma, although I think much of your historic district is commercial, but under SB 9 does not apply to any lots that are within the historic district or that are registered with the federal or state registries or with any local registry as historic properties. SB 9 does not define what constitutes a historic district or any specific standards for what would constitute a historic property. There is other law, case law mostly, about whether something is historic or not. So there are some outer parameters for what would constitute historic, but for a lot of older communities, this is a pretty significant exception to application of SB 9. And finally, as I mentioned, there's an exception to that 1 car per or parking space per unit requirement, and that is when the unit is located within 1/2 mile of a high quality transit corridor or within 1 block of a car share location. Next slide. There are also a few other restrictions on building or splitting lots under SB 9. First, lot splits can't result in the demolition and alteration of a housing unit that is currently serving moderate, low, or very low income households or rent-controlled units. You can't demolish, as I said, housing, so you can't split the lot that would result in that demolition. You can't actually request demolition of housing that is subject to rent or price controls. And any of the actions that you would take under SB 9 cannot result in demolition or alteration of housing that has been occupied by a tenant in the last 3 years, or if the unit has been removed from the market under the Ellis Act within the last 15 years. Next slide, Gary. And finally, there's a few restrictions on housing that is created under SB 9, either by lot split and or through the development of the 2 units allowed. First, the city must require that property owners sign an affidavit or applicants sign an affidavit that states that they intend to occupy one of the housing units as their primary residence for a minimum of at least 3 years from the date of the approval of the lot split or from approval of the new development. Practically, it might be challenging to enforce these affidavits because there's this intent requirement, and it will be challenging to prove that somebody was lying, basically, when they stated that they intended to occupy the housing unit as their principal residence. But it will at least first make people think twice about immediately moving or not ever residing in on these lots, and it's a potential enforcement mechanism from folks doing that. There's a restriction for parcels that have been created from a previous SB9 lot split. So if you had a 20,000 square foot lot, you split it into 2 10s, you can't come back and split one of those two lots into 2 more lots. Similarly, the same person can't perform lot splits on adjacent lots, so you can't own 2 lots next to each other and turn it into a 4-lot subdivision or parcel map. This does not mean that you can't do an SB9 lot split and then do a lot split under, or a parcel map under the Subdivision Map Act. That just means that you are specifically limited in when you are using this SB9 mechanism. And I'll just end as the SB9 discussions. I imagine there's going to be a lot of conversations, and we just wanted to touch on the main points that are going to field questions later. But really what we're talking about here is 4 units on a single parcel, or on what was a single parcel. And that can happen in 2 ways. That happens either by and that's as many as 4 units. That can happen either by a lot split, at which point there are 2 lots and the developer or the owner is allowed to then build 2 more units on each of those lots, typically a primary dwelling unit and an accessory dwelling unit on each of those lots. So that would be 2 total dwelling units on each lot for 4 total. The alternative is that somebody can have 1 unit or 1 lot, they put a duplex on that lot, and then they are entitled under SB9 and the existing ADU laws to put an accessory dwelling unit on the lot and a junior accessory dwelling unit, which results in, again, 4 dwelling units on the lot. Otherwise, what is permitted under current state law is 3 dwelling units. That would be your primary dwelling unit and an accessory dwelling unit and a junior accessory dwelling unit. So in most cases, we're talking about the ministerial approval of 1 additional dwelling unit on single-family residential zoned lots. Next slide. I think this is back to you, Gary.
Yes. So we'll talk about SB 35 streamlining now. One thing to note, the city appears on HCD's list of jurisdictions subject to SB 35 streamlining. That's where I pulled this information from. The standard in the law has to do with RENA numbers and housing elements, and now that those, based on my conversation with David and the fact that they're compliant, I wonder if HCD needs to update that. I'll just say that out loud and open that question, and perhaps it's something we should look into, and encourage HCD to update that list if needed. But in any event, we'll cover SB 35 streamlining because it is out there and it provides a slightly different process than the Housing Accountability Act. As the name implies, it's a streamlined ministerial approval process. That's the phrase. Of those 60 bills that we talked about at the very beginning, a whole bunch of them use that phrase. It removes discretion. It also takes the project out of CEQA because you're not applying discretionary approval to this project. So it applies to multifamily housing, 2 or more residential units on a parcel, 75% of which adjoins parcels developed with urban uses, zoned for residential or residential mixed use, or has a general plan designation that allows these, and at least 2/3 of the square footage is for residential use, including density bonus units. Developer has to commit to recorded deed restriction, 55 years for rented, 45 years for owned. So you must reserve at least 10% of units are affordable at or below 80% of AMI, or 20% at or below 120% of AMI, with the average income if the units are at or below 100%. To comply, rent or sale price shall not exceed 30% of gross income of the housing unit. And the inclusionary housing ordinance prevails if it requires more, as yours does. The development, excluding any additional density, concessions, incentives, or waivers, is consistent with objective zoning standards. There again, it's the same standard as the Housing Accountability Act. We've carried it over. This is part of your review of these projects. If it's located in the right zone, has the right levels of affordability, Does it apply with all of the objective design standards that are contained in your code and the other standards you've adopted? And the general plan prevails over inconsistent objective standards. So if there's something in your general plan that conflicts, that's the one that's going to control. There are lots of exceptions to SB 35 streamlining. There's a whole bunch of them in the statute. They're right in the middle. There's a long list. This covers them here. These are the types of projects that are not subject to SB 35 streamlining, even if it otherwise meets the requirements of the project that we just discussed. It's on a coastal zone, prime farmland, wetlands, very high fire hazard severity zone, a hazardous waste site, within delineated earthquake fault zones, flood hazard area, floodway, conservation lands, habitat for protected species, and lands under a conservation easement. This next one is the one that typically gets invoked to prevent a project from SB 35 streamlining. It would require demolition of housing subject to affordable deed restriction or covenant, housing subject to rent control, or housing that's been occupied by tenants within the past 10 years. And that last one is common, especially if you're demolishing some kind of existing structure. And if you think about what the legislature was trying to prevent here, they don't want to take units off the market in order to create more units. And so if there is a unit that's been occupied by a tenant in the past 10 years, they want to preserve it. But looking back and proving that and figuring out whether or not somebody's been there 8, 9, 10 years ago can be difficult, and that can often be an issue. But certainly if it's a residential unit that's been rented at any time in the past 10 years, this would be an exception to the SB 35 streamlining. The site was previously used for housing that was demolished within 10 years before application submitted. The development would require demolition of a historic structure on the federal, state, or local register. Seems to be a theme there between the HAA and SB 9 and also SB 35 streamlining, and containing housing units and units that are or were subsequently offered for sale to the general public. These are the exceptions to the SB 35 streamlining. So there's requirements. They get past that, they have the percentage, they meet the objective standards, they're going to impose the deed restriction or covenant. If it's not a public work, the developer has to certify and pay the construction workers prevailing wages. There's an exclusion for 10 or fewer units that are not public works. There's also an exemption from prevailing wages if it's not subject to the Subdivision Map Act, so you're not dividing anything, unless it's consistent with objective standards in the local ordinance and receives funding through the low-income housing tax credit or pays prevailing wages skilled and trained workforce. It's not on land governed by the mobile home residence law either. So there's a notice of intent that's required of an applicant that wants the benefits of SB 35 streamlining. They have to come out and say, we think it's subject to this, we want to proceed under SB 35. It has to include the information in a preliminary application. That's the same one that we discussed earlier under the Housing Accountability Act. There's a statutory consultation with tribes. The reason why that's included is this is ministerial. CEQA doesn't apply. Of course, if it did, there would be AB 52 consultation with tribes under CEQA as well. But that's included in SB 35 streamlining to ensure that process occurs. There are short deadlines as well in here for making determinations, just like the Housing Accountability Act. If the city determines that the development is in conflict with objective planning standards, you must provide written documentation and an explanation for the reason. Within 60 days, if it's 150 or fewer units, or within 90 days if it's more than 150. Otherwise, the project is deemed to satisfy all of those objective planning standards. This is the same process under the Housing Accountability Act, and the same potential issues will arise, which is the deadline itself, which can trigger a deemed to satisfy for the project as a whole, or a failure to include something even when you meet the deadline, which could lead to not being deemed to satisfy objective standards if it's not included. Consistent for purposes of SB 35 means that if there's substantial evidence to conclude the development is consistent. That just means that there is some evidence in the record that would conclude that based on your review and based on the information submitted. So SB 35 does not preclude planning commission, design Review and Historic Preservation Commission or the City Council from reviewing these projects. Still ministerial, you're still deciding whether or not it complies with objective standards. It doesn't preclude it, but it needs to be focused on assessing compliance with criteria and reasonable objective design standards adopted before submittal of the application, and it must not inhibit, chill, or preclude ministerial approval as follows. So public hearings can still occur under the law, but these are the standards for holding them. And approvals within 90 days if 150 or fewer units, or within 180 days if more than 150 units. So there are restrictions on parking. None if it's within a half mile of public transit, within an architecturally and historically significant historic district. On-street parking permits are required but not offered to occupants of the development. Otherwise, no more than one space per unit. The approval is valid for 3 years from approval or from final judgment if litigation is pursued, unless there's a public investment in housing affordability beyond tax credits where 50% of units are affordable at or below 80% of AMI. Approval is also valid if vertical construction is begun and it's in progress. So extensions are possible under those facts, and also if those deadlines aren't met. So the developer can request modifications before issuance of a final building permit required for construction. City must approve those if consistent with objective planning standards in effect when the original application was first submitted. So that's a reach back. It could be several years after approval. If the application took some time in order to go through the process, could be up to 4 years, potentially a little bit longer. And you're reaching back to the standards that were in effect at that time. City must use the same methodology applied to the original approval and approve or deny the modification within 60 days. However, city may apply objective standards adopted after the application if the number of units or square footage changes by 15% or 5% or more necessary to avoid specific or adverse impact. Building code objective standards always apply. So this is the only case we have explaining SB 35 and analyzing some of the exceptions under it. It was released earlier this year and is the only published Court of Appeal decision in this area. The city of Berkeley, there was a developer that proposed 260 units over 27,500 square feet of retail space and parking. So this is a mixed use project. There's a possible Native American shell mound and site designated by the city as a Berkeley landmark. Nothing of the shell mound remains above ground. There's been much disturbance by development-related ground disturbance in the area. So there's a parking lot there and an existing structure, and the city believes that there was a shell mound underneath that parking lot at some time, and it appears on a Berkeley landmark list. So the first question is the shell mound actually located on the site? That was an open question because its precise location wasn't known to the city or to the applicants. There's conflicting evidence in the draft environmental impact report, but that report concluded that the shell mound possibility exists, that it's there. So is the shell mound a historic structure on local registers such that SB 35 does not apply? Remember, that was one of the exceptions that was included earlier in SB 35. So the city sends a 90-day letter, as they're required to do. We say the project may require demolition of a historic structure and therefore not subject to streamlining. In any event, it conflicts with other objective standards. After a response from the developer, the city denies the project for SB 35 streamlining. At this point, this is still a staff back and forth. There's a preliminary application, they've now denied it. There's a status letter that's been sent that says demolishing historic structure, objective standards not met, not subject to SB 35. Of course, they're proposing multiple units. So even though SB 35 doesn't apply, the Housing Accountability Act still applies, and that's all the standards that we talked about earlier. This just gets the ministerial and expedited very quick review. You talk about 60, 90 days, 90, 180 days for approval. That's very quick. And if you think about the size of this project, it's very quick. So there's a slightly different procedure that applies here. When staff makes an administrative decision or has a ministerial duty to do something and an applicant claims that was done incorrectly, This type of lawsuit asks whether the city's decision was arbitrary, capricious, or entirely lacking in evidentiary support. Now, historically, that is a very deferential standard. It has to be entirely lacking in evidentiary support. It's pretty high, as long as there's some evidentiary support. In this case, there's a draft environmental impact report that analyzed this, concluded that the possibility existed. That's some evidence right there. It's not arbitrary or capricious under those standards either. But the court found that in this case, the highly deferential standard was inappropriate for SB 35 streamlining. The law wanted to encourage certain projects to be put in place and to be approved and to promote housing units, and decided that that standard wasn't appropriate. The court also found that there was no evidence that the shell mount is a structure under SB 35 as opposed to a site or a resource. So those terms were used differently in the different documents that were included and considered by the city when they were making their determination. SB 35 uses the word structure, not defined though. The court looked at what the usual meaning of the word structure is and thought about it. That's different than a site, which is what the shell mount probably was or was analyzed under the draft environmental impact report. So in this case, tribal consultation did not apply yet because these are later enacted provisions of SB 35. But of course, now under SB 35, tribal consultation would be required. The takeaways from this case, SB 35 applies to mixed-use development, not just to 2 or more units on a parcel for mixed use. That was sort of an open question in the way that SB 35 is drafted on whether or not it applies to a mixed use where you're actually proposing some commercial component of the project. It does. This court answered that question. The inclusionary housing fee that the city required is not an objective zoning or design review standard. That was an issue in the case. And it can be enforced later at the issuance of a certificate of occupancy. That issue was not directly before the court, but the parties attempted to raise it, and the city could not deny it for this reason. The project provided more units than inclusionary housing ordinance required, but insufficient for all categories, and that too was insufficient to deny under SB 35 because it met the percentages in SB 35, even though the local ordinance had different requirements. I'll hand it back to Ryan for density bonus law discussion.
Thank you, Gary. So this will be the last topic before we open things up for conversation. You've probably all come across the density bonus law at some point. It's been in effect since 1998 and has been amended every year except once since 2014. So it is pretty much constantly being changed, mostly to increase density bonuses and concessions and incentives that are allowed. And I'll explain what each of those are in a second. But in short, the density bonus law requires the city to provide density bonuses and development incentives and concessions to developments of at least 5 units which propose to construct affordable housing. As I'll show you in a second, the density bonuses, the development incentives, and the concessions that are provided for each affordable housing project depend on the amount of affordable housing being proposed on a sliding scale. Next slide. Gary, thanks. I think you just click through a few times. So this will have the process, if you just want to click, yeah. The process for who's eligible for a density bonus. So the first step of this process is the developer is requesting a density bonus for a housing development that can constitute, or that has 5 or more residential units. That has to be in a mixed use or residential zone. The developer has to agree to record either a 45 or 55 year affordability covenant, basically ensuring that the property will be used for affordable housing for a certain number of years. And there must be, as part of the project, construction of a threshold number of affordable, senior, or qualifying housing, or in the alternative, donation of land for affordable housing. Next slide. So the minimum thresholds for eligibility are that and you just have to meet one of these standards. At least 5% of the units being proposed are for very low income households. 10% of the units are for lower income households. 10% in a common interest development specifically are for moderate income households and are for sale as opposed to being for rent. Market rate senior citizen, so 55 and up housing developments with at least 35 dwellings meet the minimum eligibility thresholds. Projects that have at least 10% of units for very low income transitional foster youth, disabled veterans or homeless persons, or at least 20% of the units are for lower income student housing. Those are the minimum thresholds in addition to this 5-unit requirement to trigger the density bonus law. Next slide. So as I said, what we're really talking about here is a sliding scale depending on the what's being proposed here. So if you are proposing, for example, 10% very low, 10% of your units are very low units, then you get a 32.5% density bonus. You can build 32.5% bigger than what would otherwise be allowed in that space, and you're entitled to 2 concessions or incentives or concessions. If you're proposing mostly moderate income, then, for example, 44%, up to 44% moderate income property or units, then you get a 50% density bonus and 3 concessions or incentives. Really the application here is you only get to choose one of these. So if you have 5 very low and you have, 17% low, then you would choose to go with the low threshold because it offers a larger density bonus and more concessions/incentives. They don't bundle on top of each other, even though you've offered more than one type of affordable housing. Next slide. So incentives and concessions are one of these 3 things. They're a reduction in site development standards or modification of zoning code or architectural design requirements that result in identifiable and actual cost reductions. It's approval of mixed-use zoning in conjunction with the housing project if the inclusion of the commercial, office, or industrial uses will not reduce the cost of the housing project, or it includes, yes, approval of those if those uses will reduce the cost of the housing project and such non-residential uses are otherwise compatible with the housing project and other existing and planned development in the area. And it really can be any other regulatory incentive or concession that is either proposed by the local agency or more commonly by the developer that will result in identifiable and actual cost reductions to provide for the affordable housing costs or rents. So what we're really talking about here is incentives and concessions from otherwise required standards or conditions of approval that would result in a reduction of costs that the developer can then say that reduction in cost to develop this property allows us to provide affordable units where this project would otherwise maybe not be profitable. So generally, as I said, there's the table for determining how many incentives and concessions a property is entitled to. Once they've received that number, the city essentially has to approve the incentives or concessions that are being requested, with a few exceptions. One of those is, of course, if it doesn't actually result in an identifiable and actual cost reduction to the project, which is a requirement for it to be considered qualifying incentive or concession. The city can determine that a requested incentive or concession would cause a public health or safety problem. It's possible the city can decide and reject an incentive or concession for harming historic properties, or if it would be otherwise contrary to state law, or state or federal law. Next slide. This is a recent case, Schriever v. City of Los Angeles. Basically what this said, this looked at a provision of the City of Los Angeles Municipal Code, which required the applicant for a density bonus to prove that the concessions that they're requesting, or their concessions or incentives that they're requesting, are necessary to make the affordable housing component of the project financially feasible. That is preempted because it's not provided for in the density bonus law. And instead, as I said, the standard to deny a concession or an incentive is for the city to determine, based on substantial evidence in the record, that the concessions will not result in that identifiable and actual cost reduction. So in the absence of the health and safety concerns, the city really has to make this determination that the concession requested won't result in that identifiable and actual cost reduction. Next slide. The final component of this is what's called a development standard waiver. And so instead of a concession or an incentive, this is just waiving partially or fully an application of an otherwise applicable development standard. This applies if compliance with the development standard would physically preclude construction of the housing development, utilizing the density bonus and concessions or incentives. In that case, the applicant can submit a proposal for a waiver or reduction of the development standard. Unlike the concessions and incentives, of which you get a limited number based on the amount of affordable housing you're providing, there is no maximum limit on the number of waivers an applicant may request. Waivers only apply to development standards, as I will talk about in a moment. But basically what this is saying is if there's some standard that would preclude construction of a housing development at the size that is otherwise allowed by the density bonus and otherwise allowed by concessions or incentives, then they can be waived under this process. Next slide. So some development standards will include the total density allowed on lots. Height limitations are commonly waived in these cases. So if you are allowed a density bonus, a pretty large density bonus, but it's a small lot, you might be allowed to waive height limitations. Parking ratios, so parking spaces per bedroom. Setback requirements, again, on smaller lots where a lot of density is allowed, you might be able to push out to near the edges of the property. Floor area ratio, lot coverage, open space requirements. So if you would otherwise have to leave out a certain amount of open space, you no longer are, or perhaps minimum lot size. Next slide. And finally, the density bonus law, if it applies, allows developers to request reductions in parking ratios. They set, as there's a table for everything, the table here sets the standards for what parking ratios are allowed, or what parking ratios applicants can request. For small 0 to 1 bedroom units, it's half a parking space per unit. That can go up for 4 or more bedroom. And then for these projects that are, for certain projects that meet generally pretty onerous requirements, rental projects that are 100% affordable to low-income households and within 1/2 mile of a major transit stop, for example, no parking spaces can be required per unit if the applicant requests a waiver of the parking requirement under this section. Next slide. That's all for density bonus.
Great. So as we conclude here, looking forward to this year in the legislation beyond what's coming up. Discretionary review is likely to be secured for single-family homes still, but more severely restricted for other proposals for 2 or more units. Objective standards will continue to be a standard for the 2 or more unit proposals, and development of those is worth doing and thinking through, and perhaps creating a standalone objective standards for certain types of projects, maybe for all Housing Accountability Act projects, so they're in a single place. And we would definitely expect more legislation on these and other topics. With that, we are happy to take questions.
Thank you so much, Gary and Ryan and Jeff. And this is very detailed, informational, and educational. It's very helpful. Right now, let's now open the question and answer. And we are, all right, yeah, you just tell your name and,
So this,
yes.
Talking to the microphone somehow? Is it this one?
Yes,
It'll catch up, we don't have to.
okay.
yeah, just loud your voice.
All right, Gary and Ryan, can you hear me?
It's a little low, but we can, if there's a way to speak up, it'd be great. Otherwise, we will do our best to hear.
Okay, David Storr is trying to figure it out. My question is, with regards to SB 9 and the historic district, is there any particular verbiage around when the historic district was established, as opposed to if it was established before SB 9 or after SB 9? If a historic district is established later, does it still apply that it cannot be in a historic district?
Ryan, do you want to take that for SB 9?
Sure. So no, there is no language in SB 9 about when the historic district was designated or when the historic property was designated. So theoretically, a historic district that is redesigned or that is expanded next year or in 5 years, assuming this isn't changed, would be exempt from SB 9. And frankly, there is, in the legislative history for SB 9, there was a bit of hand-waving and perhaps hand-wringing about the fact that this is a pretty large exemption, that the state law doesn't define a historic district or historic property in any discernible way, and that gives cities a lot of authority to designate historic districts and to designate historic properties moving forward still.
Thank you.
Councilmember. Thank you, Vice Mayor Ding. Piggybacking off that question regarding historic districts, in the city of Sonoma, we have a historic overlay district that encompasses a significant part of our east side. And in SB 9, it says the development is not located within a historic district or property included on the state historic resources inventory as defined in section 5020.1 of the Public Resources Code, which then defines a historic district. And so when you're saying it's not really defined, are you saying that that only applies to the property in the state historic resources inventory, or can we use the definition for historic district in the Public Resource Code? Did you hear me?
Did you? Yeah, I think so.
All right. Yes, one second. I was just pulling up the language, just so so the first section of that sentence is the development is not located within a historic district or property included on the state historic resources inventory as defined by that public resources section, as you mentioned, or within a site that is designated or listed as a city or county landmark or historic property or district pursuant to a city or county ordinance. So that or within a site designated or listed is pretty broad language.
So would so we do have like a large historic overlay district. Would you think that that would qualify as exempt from SB 9?
Likely, yes. It would be a site or a site listed as or designated as a district, a historic district pursuant to the city ordinance, yes.
Okay, thank you.
Next question. Commissioner Barnett.
Thank you. I've got a series of questions, probably about a half a dozen. First, and they should be pretty straightforward. With regard to the 5-meeting limit, how are continuances considered in that counting?
They are considered a new meeting, so it's a separate meeting.
Okay.
Correct me if I'm wrong, Gary.
I think that's right. The way that it defines the hearing, yes. And that's to prevent continual continuances like that for a long time to evade that 5 years.
Okay. Under your slide number 30, Senate Bill number 9, it talks about the minimum of 800 square feet in floor area, would an objective standard of a maximum of 800 feet in floor area be acceptable? Can the city establish a maximum size? I ask that because if in fact these laws are designed to encourage more affordable housing, part of the formula for that is based on size. So is it possible for the city to impose a maximum standard on units after a lot split?
Yes, that would be considered an objective standard. And there are some agencies that are moving forward with, I've seen, for example, one city that is proposing 1,200 square foot maximums. That is something that some agencies are doing in response to this.
Okay, thank you. With regard to your slide number 35, regarding overdevelopment and the requirement that the applicant intend to occupy one of the housing units as a principal residence. This obviously is a roadblock to corporate owners of rental properties, am I correct?
Presumably, yes.
Presumably, or yes?
I can't speak for the legislature, but I would assume that is their intent.
Okay, thank you. And I think I've just got two more. If on your slide number 43, it speaks to a public investment in housing affordability, but it doesn't, you didn't state how much longer the approval process is if public investment is made.
What was the slide number again, so I could pull it up?
43. In other words, you get 3 years from approval, and unless public investment in housing affordability and so forth. My question is, how much longer is that approval valid if there is public investment?
Yeah, I'm not sure that SB 35 has that in there, but I'm happy to confirm that and follow up.
Okay. And then my last question is, under incentives and concessions, while I understand the idea of offering incentives and concessions to theoretically lower the cost of a unit or the price, ultimate price to the public of a unit, how does one verify that in fact it has ended up with that result? In other words, you can make the case that if you let us use a cement board instead of wood, I'm just coming up with something off the top of my head, it'll be cheaper to build this structure, and therefore we'll be able to make them available to tenants at a lower price. How does one verify that that in fact actually occurred? In other words, you need the threshold of the original price under the projected construction cost as originally applied without concessions. How do you determine the actual effect of those concessions on the ultimate price?
So a few things. First, that standard applies, of course, because it has to, at the application stage. And so state law provides that that the city basically has the burden of showing that a concession that has been requested doesn't actually, or will not result in cost reduction, in an identifiable and actual cost reduction. They use that word actual in there, in state law and density bonus law, but there's no mechanism for then confirming that there has actually been an identifiable and actual cost reduction. So that's one part. There is no process for confirming that our math and their math was correct, that some concession or incentive would result in identifiable and actual cost reductions. The second part of that is that the identifiable and actual cost reductions relate to the cost of the project as a whole, but you don't necessarily have to link them directly to the sale price or to the rent that's charged for the property, that will be set based on what level of affordability they have stated that they are going to sell or rent the property at. If it's very low or moderate income, and that will be restricted by deed restriction that would be enforceable if they ended up not meeting those standards.
Okay, so if I understand you correctly, the incentive or concession would basically increase the profit margin for a developer without necessarily affecting the ultimate price of the units.
So, as I understand the legislature's intent, it is that, which is maybe echoing developers' arguments, is that the developer will see a reduction in their total costs because of the incentive or concession. That allows them to offer affordable units while still making a profit. So what they're saying is without the incentives or concessions, they would be unable to develop that property and offer the amount of affordable units they are offering while still making a profit.
Okay, that answers all my questions. I'll just say that what disturbs me most about all this legislation is there are no affordability mandates at all in terms of the numbers. There are, of course, the concessions and the density bonuses and the encouragement of creation of affordable housing, but I don't believe that we've got a housing crisis. We've got a housing affordability crisis primarily, and I don't see any of this legislation addressing that problem whatsoever. Thank you.
Thank you so much, Commissioner Barnett. Next question, please. Commissioner and Council Member. All right.
Yes, I'm curious that in a small community like Sonoma, where we have only so much infrastructure capacity, does that play into the interpretation or the use of these new bills in terms of, we can accommodate so many new units per given year, but what I've heard for the past hour and a half is just the motivation to do more and more and more. Can we as a community say that we have inadequate infrastructure to support some of this building?
Gary, do you want to take this one?
Yeah, so if I understand the question correctly, we were talking about the physical space to actually accommodate these
No,
potential
what I'm saying is that we have a sewer plant, we have a certain capacity, we have a certain water delivery system, certain capacity. We have had limitations in the past of so many units per year. Now we're being strongly encouraged to accelerate our amount of development, but again, we may have limitations to support that. Such was the one case study that you set out of Stanislaus where they couldn't deliver water. So again, my question is there an opportunity for our community of Sonoma saying, love to do it, but as of 2021 or 2022, we do not have the capacity to support that?
There are some moratoriums on new water connections going in. Some water districts are doing that, and certainly some cities are considering it too. What I will say on capacity for these, generally these laws don't confront that issue head on, and they're concerned about the individual application that's being submitted to the city. I'll note that under SB 35 and also under Housing Accountability Act, the impact fees still apply. There are bills in Sacramento to reduce or eliminate impact fees for these projects. They have not been successful so far. But that money, of course, connection fees, things like that, would go towards additional infrastructure to support these projects from a cost perspective. But the short answer is no, the legislature is not concerned about the more global picture of its impact on infrastructure more broadly. They're concerned about getting more units in and on an application by application basis.
And I'll just add, I think that there is a possibility, given the water connection moratoria that we've seen in a few places, that some agencies will make the argument that there is an inadequate amount of available water, and that creates a public health and safety consideration that allows the city to deny projects under the Housing Accountability Act or some of these other laws. That is something that I think might be tested at some point in the future through litigation, although I haven't seen any cases yet. There's certainly an argument there that is a significant public health and safety concern, that there's not an inadequate water supply, which is why they've prohibited new connections. The issue there is, one, these laws are written very broadly to focus solely, as Gary said, on building more units and not on some of these serious impacts on the local communities. But two, it's still challenging, or I think it will be challenging to identify how a specific project affects the availability of water. And as Gary mentioned, what the legislation is really looking at is the processing of individual applications and specific individualized impacts from those applications. So there's a little bit of an uphill battle in making those arguments.
Thank you.
One thing I would add to that as well on conditioning these projects. So in the Housing Accountability Act slides that we discussed, it talked briefly about conditions. There's also potentially conditions imposed under SB 35 as well. The restriction there is that the conditions cannot reduce the density of the project, the conditions can't. And for affordable projects, they can't make the project infeasible. So it's really a two-step question. The first one is, can we deny this project at all? If it meets objective standards, can we make these findings? If not, we need to approve it. But the second question is, what sort of conditions can be placed on it once the approval goes through? So you're approving it. The Housing Accountability Act says you can't deny it if it meets those requirements, but you're not, you're approving it. There are still the possibility for conditions to be imposed on it. Conditions can relate to things like water into the well, only when a connection's available, things like that down the road. And you can place other conditions on it as well. That's sort of the remaining piece of this that's still available beyond these objective standards, because those are the standards you're applying and deciding whether or not you have to approve the project in the first place. But once you conclude that, there's still condition authority. HCD recognizes condition authority, and the Housing Accountability Act recognizes that too.
Again, thank you.
Thank you. Is there any more question? Commissioner Boha? Yeah.
Yeah,
Question one after.
Thank you. My question relates to SB 35, which only applies to the cities and counties that are on a list released by HCD, and you said we're on that list?
I did say, yes, you are on that list. There's a standard in the law about meeting RENA numbers and your housing element as well. And HCD has an SB 35 information page, and they have a list of jurisdictions that are on it, and the city is currently on that list.
I guess my question is, I was under the impression we had met or exceeded our RENA targets for the 5th cycle. So I'm just curious why we're on that list.
Yeah, and I do think that's worth following up with HCD on as well. And that was my impression too from my conversation with David this morning.
I mean, in 2019, we issued building permits for the Ultima drone and Mockingbird, and as of 2019, we exceeded our RENA numbers. And so I would like to investigate that and perhaps remove us from that list if possible.
So this is David here. Christina and I brought this question up to HCD. And Christina, correct me if I'm wrong, but basically the conversation was, yes, you've got your numbers now today as of the day that we're making the phone call, but halfway through your cycle, when they make a determination under the statutes, we had not got those projects that you were talking about in their bucket when we do our annual report each April of each year for the prior year, calendar year. So today, yes, we've made it. That was in the newspaper the other day on all. We've met it exactly on the very low income. We've exceeded it on the low income and the moderate and the above moderate. So we've got 170 units now out of our 137 under our current 5th cycle RENA. But when they did the midpoint analysis, for the SB 35, we had not met it, and that was their determination.
So they looked at our numbers at the end of our 2018 year, which was submitted in 2019. And in that year, in 2019, we were deficient in a couple categories. And so they look at each individual category and not just the total as well.
I thought they updated every year.
Just twice. So they did it once in 2019, and then they'll do it once at the end. That's what we've been told.
Okay, well, I have further questions about this, but I'll do that later.
We do too.
With you two. All right.
All right. Any more questions? Otherwise, I will open to the public. All right. Yeah.
Let's see if can we have them maybe come over here and we'll put the mic? I don't know if this, hey, there you go, that might work. There's a podium.
Just a 3 minutes limit, just like in a regular. Thank you.
Council members and commissioners, I'm Dennis Aftergut. I live at 1315 5th Street East. I am a leader of a 2021 organization that is called Community Alliance for Planning Sonoma, CAPS, Community Alliance for Planning Sonoma. And our mission is to encourage smart housing, not paint by the numbers housing, but housing that is smart for affordability, that is fire safety smart, that is drought smart, that is design smart, and that is environmentally smart. We're not a NIMBY organization, we're not a YIMBY organization, and Commissioner Barnett, if you'll indulge me, we're not a ZIMBY organization. I want to speak here to the sort of overarching issue that's been identified and that some of these questions really go to, and that is the issue of local officials' discretion and control in these important matters versus state mandates. And so I don't bury the headline. My message is there some way that a community organization like ours can help you? Because we believe that you are the people who have your finger on the pulse of local conditions, and that you're the heartbeat, really, of representative government because of that. Whereas mandates like these that come from the state, these kind of one-size-fits-all mandate, they're going to do some damage in places where one size doesn't fit all. And just to take an example, and you're going to hear a little bit more from Stuart, you're going to hear from some other of our members, these RENA numbers that become increasingly impossible are going to put tremendous pressure, as the commissioners and the councilman have said, to put housing anywhere, including, this is just an example, on egress routes. Somebody, it may have been you, Kelso, mentioned the limited number of infrastructure.
Excuse me, 30 seconds.
30 seconds, okay. And so that could create a situation like Paradise, and those state officials aren't going to be there. So ultimately, I just want to say, on issues like dealing with the RENA numbers, with the bureaucracy in the state, is there any way we can help? Can we write letters? Can we help you form a community advisory board on how to at least retain the discretion that you now have? Thank you.
Thank you. I don't think this is a question, just like your comments. Right?
I'm sorry?
This is just only your comments, it's not a question for our attorneys.
No, it's not a question for the lawyers.
Yeah, thank you. Yeah, next one.
Honorable Vice Mayor, council members, and commissioners, I am Callum Weeks, Policy Director for Generation Housing, where we advocate for more diverse, and more affordable housing. We, the state, our county, and the city of Sonoma are facing ongoing housing scarcity and affordability crises that threaten our residents' ability to meet their basic needs, causes commute-related greenhouse gas emissions, and causes a workforce shortage that hamstrings our local business and economy. There is not one solution to this crisis. There are many, and there must be many. We need to use all the tools in our toolbox, and SB 9 is one. In his SB 9 signing statement, Governor Newsom said, making a meaningful impact on this crisis will take bold investments, strong collaboration across sectors, and political courage from our leaders and communities to do the right thing and build housing for all. SB 9 is a great start to ending exclusionary zoning across the state, and it can be here. We cannot forget that exclusionary zoning has its origins in the intentional exclusion of low-income families and communities of colors from certain neighborhoods. 65% of the city of Sonoma is currently zoned for single-family zoning homes only. Opportunities in high-resource neighborhoods are scarce, and it maintains the racial and income segregation in the cities and its schools. And let's be clear, this is a modest start. Studies from cities ahead of us, like Portland and Minneapolis, show that allowing small plexes and single-family lots increases housing units with only slight increases in density and still allows for construction of single-family homes. And study after study has shown that increasing density does not increase crime rates, it doesn't hurt school performance, and it doesn't reduce property values. City of Sonoma has 5.5 low-wage jobs for every affordable home. The most common of these jobs consist of positions in Sonoma's critical wine, hospitality, and agricultural industries. SB 9 can help get these folks out of environmentally disastrous commute traffic, out of working second and third jobs, and out of unhealthy, overcrowded living spaces. Finally, SB 9 increases the right of property owners. It creates opportunities for intergenerational living, housing for caregivers, and it offers opportunities for additional income streams for folks with fixed incomes. We urge the City of Sonoma to be a leader in creating housing opportunities for the members of our workforce, housing opportunities in high-resource neighborhoods that are nearest their jobs, and in expanding the property rights of its residents. We urge the City of Sonoma to support broad implementation of SB 9. And since they were unable to have someone here, I'd also like to say that the Sonoma Valley Collaborative is very much in line with these sentiments and echoes everything that was just said. Unfortunately, due to the short notice of this meeting, they were unable to attend. As always, I thank every single one of you for your time and for your leadership. Thank you.
Thank you so much. Yeah, can you approach to the mic? Okay. Sure.
My name's Chris Ryder. I live at 985 Friar Creek Drive. I do have a question for the attorneys. It's more of an interpretation. Under SB 9, it says local governments and officials are prohibited from doing one of the following, which is imposing regulations that require dedication of right of way or the construction of off-site improvements for the parcels being created as a condition of issuing a parcel map for an urban lot split. Can you tell us how that, interpret that as it relates to the City Municipal Code 19.69.050, which basically gives the city the right to impose right-of-way on public services like sewer, sidewalks, driveways, underground utilities, etc. Can you just talk to how that might impact the city's ability to enforce those type of requirements? Thank you.
So I think we're happy to talk about SB 9, but we're hesitant to apply it to a specific provision in the municipal code. We haven't reviewed that in preparation for tonight's meeting, and so not prepared to give a detailed analysis on that. We'd need to review the whole section and ask a lot of questions before we could give that opinion. But as to the SB 9 question specifically, do you know the provision he's talking about, Ryan?
Sorry, I'm muting myself. I can take a look at it. I don't off the top of my head.
We're happy to pull that provision up and talk about it. If there's another question in the meantime, I know we can come back to this one.
All right, another question, please.
Hi, I'm Carol Marcus, Sonoma, 873 First Street West. This is a question about SB 9, just a clarification, and because it may have already been answered in one of Commissioner Barnett's questions, but can the city write objective standards that are limited to SB 9 parcels only, that don't apply to the base zone?
If I understood the question correctly, it's whether or not the city can write objective standards that only apply to SB 9 projects or proposals.
Correct.
So, considering that SB 9 applies in single-family zones and the types of homes that it's applying to, the design standards would need to apply to homes generally. And because they would apply to all single-family homes, I'm not sure how you would apply it to SB 9 homes because they would capture all single-family homes. You follow me there?
I mean, for example, the example that Larry Barnett made about a maximum unit size of 800 square feet, which obviously is not the case in the base zone, but that would be permissible?
So I do think there's a way to propose a design standard in that way. And you would frame it as applying in, the short answer is yes. I think there's a creative way to come up with a design standard that would capture the split and the duplex and the minimum or maximum square footage that you're discussing.
Okay.
Yes.
Okay, thank you.
Thank you, Carol. Another question, please?
Go ahead.
Hi.
Hi, I'm Johanna Patry, 621 Napa Road. My question is really general. How will the city reconcile growth management policies and provisions with these housing mandates and rights that are before us?
Is that a question for us? And if so, could it be repeated?
Yes, if you have an answer.
Thank you, Johanna.
Could you guys hear the question?
I was not able to hear the question. If it could be repeated for us, yeah, I can hear it.
The question was, can you comment on how SB 9 and these housing bills may affect our growth management ordinance policies and sections, code sections?
The question is how SB 9 will affect your growth management policy generally.
Currently, the limit is 65 homes per year on average.
Mm-hmm. So I would need to take a look at that policy and read it in detail in order to answer that question.
All right. How about Gary? Do you have any comments for this question? Any another question, please?
Do you have an answer to the previous question?
Looks like no any other questions from the public.
Yeah, not a question, but
Okay.
a sample. Anybody see? So I'm Stuart Saunders, 1383 Larkin Drive. I'm also a member of CAPS that Dennis presented. My biggest issue is an infrastructure question, and it's also fire safety concerns. If you look at some samples that we have up here, that is in August, excuse me, a little nervous, found out about this late last night. If you look at the sample on the left, that is Napa Road and right near where I live. And that's when they shut down just one lane so that there was only the left turn arrow on Broadway. So it's Broadway and Napa intersection. And that traffic, for normal traffic, not emergency, just everyday traffic, was backing up a half a mile from the stoplight. Because if you're at the stoplight and the straight and the right-hand turn were blocked off, you have to wait. If somebody's in front of you and they want to go straight and you got the left turn signal, everybody had to wait through the light. So it's an example of a non-emergency situation where traffic will just jam up. And my point is that the infrastructure in Sonoma already is weak. It's not going to support high-density housing built up on any of the major streets. That with issues like that in 2017, you look at the right, that is, that poster was a presentation to the school board when they wanted to have 2,500 seats at the new stadium. And they reduced to 1,300 seats because of fire issues, because of capacity issues, and it looks like people know some other stories as well. So we really implore that fire safety is really taken to heart. I've got more information from the Paradise fires. We don't have the same geography as the Paradise fires. We have a very similar road system. If I was able to put up two maps side by side with no labels on them, you probably couldn't tell which city was which city. So we all have the same issues. Broadway has a lot of issues now with up to 600 cars pouring out of the high school, the middle school, 144 unit acute care facility next door. They need ambulance service during, and I'm talking 2017 was a simple emergency in terms of spreading out people evacuating out of town. If we get one like Paradise, you know the rest of the story.
Thank you for your comments.
Thank you.
Thank you. Questions from public?
This is Ryan Reed here. Just want to address a question that was raised earlier about dedications of right-of-way or construction of off-site improvements. Can you hear me?
Yeah. Yes.
Great. So that section is Government Code 66411.7B3. And what that says is that local agencies like the city can't impose, basically can't require dedications of right-of-way or construction of off-site improvements as a condition of allowing a lot split under SB 9. So it's a pretty limited, that there can't be dedications or construction of, or off-site improvements as a condition of approval of a lot split under SB 9. That is not the same as a condition of approval for a parcel map, generally under the Subdivision Map Act, or a subdivision map under the Subdivision Map Act. Again, as Gary said, I'm not familiar enough with the provision that was referenced of the Sonoma Municipal Code to give an answer as to its application here, but that is what this provision of state law says generally.
Thank you, Ryan. If you know any questions from public, I will bring back to Commissioner and Council members for any final comments or questions. None? All right.
Can I ask a question?
Oh, sure.
This is a little bit unrelated, but I know that there's some other bills that have touched on automatic map extensions, and I was wondering if you can comment on that. I'm too quiet. Could you hear me? We lost him.
No, I'm sorry, is that a question?
Yeah, my question, so it's not about SB 9 or any of these specific housing bills, but I was wondering if you're aware of any tentative map automatic extensions that have happened historically, if there's any of those that might apply to the city.
Yeah, so I think you're talking about occasionally the legislature will pass a law that extends all the tentative maps for a period of time that would otherwise expire or need an extension. Is that what you're referring to?
Correct.
Yeah, so there was a law, and I think the bill was 14, the number's escaping me. It took effect late last year as we were in the middle of the pandemic, and it did extend tentative maps that were set to expire during the pandemic for an additional 18 months, I believe. So if there was a tentative map or some other, it actually applies more broadly than just a tentative map too. For other approvals, it extends it up to 18 months. That's the only one that I'm aware of recently, and I'm not aware of any other that are being proposed currently. And that extended everything for another 18 months.
Thank you.
That's a good answer. Okay. All right. Anybody else? All right. Thank you again, Ryan and Gary and Jeff. Today is a wonderful night for us to study the new law and address our local issue. We need a time to digest what is new from the state, and hopefully we can use this kind of law and serve our community. Thank you so much. The meeting is adjourned. Good night.
Thank you for having us.
Yes, thank you.
Actually, I didn't scare you off, Carol.